Hey guys, welcome back to the channel Meet Praneet. In today's video, we are going to discuss the recent ruling that US Supreme Court took on this Friday, 28th June 2024 regarding the Chevron Deference. And before we move into this and see how this is impactful for people who apply in EB-1 category, let me first congratulate all the Indians across the globe or cricket fans that India made history by winning the ICC T20 World Cup on 29 June 2024. This was historic because it was after 17 years India won the ICC T20 format World Cup. They have won the 2011 the 50 over ODI World Cup as well, but this was really historic because it was 13 years after that trophy that India won this, and we came very close last year. We were in the finals, but that was a sad ending. But today, the Team India has done a has played a historic match. Now, let's move into the Chevron Deference, right? Now, the very first question that you must have is what is this Chevron Deference, right? And how it is important or applicable or interest for EB-1 applicants. Now, Chevron versus National Resource Defense Council or Chevron Deference, which will be coming on your screen, this is something that I read on Wikipedia. This decision was ruled in 1984, and the idea was that US court at that point pointed that whenever there is a lack of information or there is ambiguous statute or there's some information that is lacking to understand the law or make decision, the US courts would defer to the decision or the basically whatever the US federal agencies decide, and they will use that as the source or to understand or make a decision, right? So what happened is after 40 years in 2024, 28 June 2024, US Supreme Court has overturned that decision. Overturned Chevron versus NRDC or Chevron Deference. Now, why this could be very helpful for people who apply in EB-1 is because USCIS is also a federal agency, and USCIS in EB-1, specifically in EB-1, has a Kazarian analysis, or you would say the analysis where they decide how one profile is better than the other and why one profile should be given EB-1 when compared to the others. Even though, let's say if we take an example, there are two cases, case A and case B, both case A and case B are able to complete the three criteria requirement, but only one would get a chance to get a green card or an I-140 application approval because USCIS has some laid out terms, qualitative analysis, Kazarian analysis, that what they call, based on which they decide whether one profile is better than the other or is more applicable towards EB-1 than the other. Now, let's say based on this, a case is denied. And I'm here referring to some attorneys' post like Samir Khetkar's and others on LinkedIn, where they kind of revealed this information and they described how this will work. Now, let's say after this overturn of Chevron Deference, USCIS denies the case in EB-1, right? Let's assume that is Mr. X or Mr. John Doe, and John Doe's case is now denied in the EB-1 category. Now the John Doe can go to the US court, or maybe the attorneys can file a case on his behalf asking for why or that decision was taken. And now USCIS, in this case, now the courts would not just use the USCIS rule book or whatever they have used to decide. They would want more information. They would ask for specific information on how this case was decided. And this could be a challenge, right? I'm not sure how it will pan out for the earlier cases. I think the court would not allow for earlier cases to be retested. But anyone who might get denied now may come back with their attorneys and they ask USCIS what was used in this analysis, or what was the information they used to take a decision on this case. So I think the court has more power now, I would assume. Again, I'm not a defense attorney and I'm not any attorney, so to comment on it, but I think this is what I have read and understood from the sources, and I think I wanted to put this information out. So anyone who is applying in EB-1 category, it's a good news for you, because now if you get a denial, you have at least some more power at least to go back to the court and ask the court to look at the case, decide whether that was a true denial or maybe there was some information that the USCIS has missed and have not checked or something like that. So I think overall this is a great decision, specifically for people who apply in EB-1 category. Again, based on the videos, if you would go on YouTube and search for other videos, there also can be downsides to this decision as what I'm seeing for the other videos. But coming to immigration side, specifically EB-1, where USCIS has some ambiguity or there is no clear rule book on how they decide, the qualitative analysis is where this could be very helpful. So with that, I wanted to share this information and make sure you understand what this ruling is and how this could be beneficial. Now, I have another important announcement to make. I have started a new podcast series. This podcast series will start from this Sunday when this video will be out. And I will start recording the stories of people who want to share what was their struggles, what were their hurdles, what were their wins, loss, everything. As an immigrant or a non-immigrant, how you came to US, what was your journey, how your journey or their journey specifically can motivate you and can help answer your question is what this podcast is all about. So that series will start soon. You will start seeing those videos pretty soon. We have got a lot of interest. We've got a lot of registrations. I'm really excited to share and cover those people's story and help you guys out in figuring out your challenges, your questions. So with that, I wanted to say thank you and I'll see you in the next video very soon. Till then, bye-bye.